now is Mike Davis, former chief counsel to the Senate Judiciary Committee under Senator Chuck Grassley of Iowa, and a proud America First patriot. He joins us on the Stone Zone now. Mike, thank you so much for joining us.
Thank you for having me.
Great. So you almost don't know where to start. This ruling in New York by a New York state judge essentially, and I'm not an attorney, you are, but essentially destroys Donald Trump's real estate enterprises in New York. It ends his business certificates, his ability to do business. It essentially takes control of his real estate properties and would move them to a third party. Not clear whether that is for management or whether that is for liquidation. The whole thing seems un-American to me. What's going on here?
Yeah, this is part of the Democrats' lawfare and election interference because they fear they can't beat Trump on November 5th, 2024. After they've impeached him twice, they've indicted him 4 times, and then they have this bogus civil fraud lawsuit brought by New York Attorney General Tish James, this Democrat partisan attorney general who campaigned on getting Trump, and she brought these fraud allegations for the non-fraud of a businessman paying back sophisticated Wall Street banks in full with interest. And they're trying to say that Trump inflated his worth, his net worth, when he applied for these bank loans. Well, first of all, he didn't. Like, one example is they say that Mar-a-Lago is worth only $18 million. If you look at Mar-a-Lago, it's like 20 acres down in Palm Beach on Billionaires Row. I think it's the only property down there that touches both the intercoastal waterway along with the ocean. And so a tennis court at Mar-a-Lago is worth more than $18 million. But they're saying that Trump somehow committed fraud because he said it was valued substantially more than $18 million, right? That's part of that. But setting aside all this, how is there fraud? Who was damaged by this supposed fraud where Trump paid back these banks in full with interest? They have on these financial disclosures that you make to these banks to secure these loans. These disclosures clearly say you can't rely on this. Do your own due diligence. And you think Trump is duping the most sophisticated banks in the world, these Wall Street banks? Of course not, right? This is just part of partisan lawfare by President Trump to take him out. And Tish James got this Democrat New York judge, Arthur Engowan, or whatever the hell his name is, to go along with this nonsense. And this judge just ruled by fiat, no trial, let alone a jury trial, that Trump committed fraud. Before the trial is supposed to start, this judge just said, sure, Trump committed fraud, even though there is disputed evidence that you should try to resolve in a trial by a jury. So this is garbage. This is Marxist type tactics that you see from the Democrats. This judge also said he's going to pull President Trump's business licenses along with the business licenses of Trump's kids in New York. This is just outrageous what they're doing to him. These third world Marxist dictators would blush at how brazen this is, what these Democrat prosecutors and Democrat judges are doing to President Trump.
Yeah, it does seem to have a certain Mad Hatter quality to it. In other words, first we'll have the verdict, then we'll have the trial. It really makes very little sense. Does New York State allow an interlocutory appeal? In other words, can Trump move this partial decision made by the judge immediately to the state appeals court?
Well, Trump tried to do that, and the appellate court, predictably, because New York has become a hellhole of Democrat judges and lawyers, this New York appellate court said no, the trial has to proceed. I mean, what is this New York judicial system going to allow here? They're going to let a judge just decide without a trial, without a jury trial, without considering all the evidence and witnesses. They're just going to look at a motion by this Democrat New York Attorney General Tish James, who is Trump deranged and campaigned on getting Trump. This Democrat judge is just going to look at her side and say, yeah, Trump committed fraud. We're going to find that he committed fraud, fine him, fine his attorneys, his reputable attorneys. This judge issued fines, sanctioned all of his attorneys for making valid legal arguments, and now they're just going to yank his license away from him. This is outrageous what they're doing. And this is what I say to these Republicans who were awfully quiet during this lawfare against President Trump. I've been screaming at the top of my lungs for 13 months about this since the Mar-a-Lago raid last August, because guess what, guys? This is not going to end with President Trump. President Trump is simply in their way. This is not our parents' or grandparents' Democrat Party. These are not liberals who love America and just disagree with conservatives on the best way to get there. These are leftists. These are Marxist. They hate America. They hate free speech. They believe in censorship. They hate due process. They believe in Me Too, presumption of guilt, and politicized and weaponized justice systems. They hate equality. They believe in BLM equity. These people are out for power. They're out for our heads. Trump is simply in their way. And I would just remind people who don't understand this, just look at 100 years of Marxism with 100 million people who were killed by these Marxists. They don't just stop with the non-Marxists. They end up killing everyone, right? So people need to stand up right now against this lawfare, whether it's through these 4 indictments for non-crimes or for this bogus civil fraud lawsuit by this Democrat New York Attorney General and this Democrat New York judge. These are republic-ending tactics. If they can take out a former president and a potential future president who is a billionaire, just imagine what they can do to the rest of us. Look what they're doing with parents protesting at school board meetings because they're outraged by gender chaos and the resulting rapes in their schools. Look what they're doing to pro-life Christians praying outside of abortion clinics, throwing them in prison. This is not going to end well for our country, and it's time for people to wake up and stand up to this lawfare.
Yeah, it is kind of counterintuitive. The more they attack President Trump with this tsunami of lawfare, whether it is in the District of Columbia, whether it is in Manhattan, New York, whether it is in Atlanta, Georgia, whether it is in South Florida, the stronger he gets politically, the more Americans see through this. We clearly have a collision coming because they do not intend to let the president run for re-election unencumbered. He is, at this point, leading by either 40 or 50%. He has decimated the opposition within the Republican Party. He's left the Republican establishment sputtering. He has energized the grassroots. His outreach yesterday in Michigan to UAW members was one of the most extraordinary, historic things I have seen in American politics, which will only hasten the realignment of working class people into the America First Republican Party of Donald Trump. But their answer seems to be more lawfare, more abuse of the judicial system to try to destroy one man and his movement. I have to believe that it is not coincidental that the judge in New York issued this unilateral ruling, sans a trial, on the very same day that House Republicans absolutely, sorry, Jerry Nadler, established payments from China directly to Hunter Biden, listing Joe Biden's home as his home address. This, of course, flies in the face of Joe Biden's bald-faced claim that no member of his family had ever received a penny from China. Mike, do you think this is just a coincidence?
No, of course not. Every time there's bad evidence that comes out on Joe Biden and Hunter Biden or James Biden or one of these other scumbag sleazeball Bidens, they go after Trump. They've done this repeatedly. They've done this for years. They went after Trump twice. They impeached him twice one time for merely asking questions, doing his job as the president of the United States to make sure American citizens and American politicians are not engaged in foreign corruption and bribery. He merely asked about this, about Joe Biden, his $10 million foreign corruption and bribery scheme with Burisma in Ukraine. What did the Democrats do? They impeached President Trump for merely asking. They impeached him twice. They've indicted him 4 times. They brought this civil lawsuit, and the next thing they're going to do is they're going to try to disqualify him under the 14th Amendment to the Constitution. They're going to try to say that this provision of the 14th Amendment passed after the Civil War to disqualify Confederate sympathizers and soldiers who engaged in insurrection and rebellion against the United States. They're going to try to turn that on Trump. They're trying to do it now to say that even if President Trump has the support of the American people, even if the American people want him to be the next president of the United States, they are just going to have their Democrat judges and their Democrat hellholes remove President Trump from the ballot and have President Biden win by default.
That is certainly a draconian prediction. Let us pray that it does not come true. Let's come back to the 14th Amendment question in a moment, Mike. I'm curious about your views on this proposed protective order, really a gag order in the District of Columbia. The prosecutor, Jack Smith, the special counsel, has proposed essentially a gag against Donald Trump, discussing any aspect of that case, but also discussing the broader connotations of that case. He is a duly qualified candidate for president of the United States. He has an absolute First Amendment right. I have been down this particular road. Last night on MSNBC, Andrew Weissman defamed me yet again. No, I did not threaten a federal judge during my trial. No, I did not lie about it. I have addressed this very extensively, including under oath. The fake news doesn't like my truthful narrative, so they rewrite history. That was used as an excuse to gag me. I appealed that gag to the D.C. Court of Appeals, who sat on my appeal for 8 solid months. Those are 8 months in which I could not comment on anything, not just my trial. I could make no public comment on any issue. I was sustaining very substantial damage from CNN and MSNBC and the Washington Post, the dominant newspaper in the jurisdiction in which I was to be tried. But the judge had no concern about those news reports tainting a jury. It was my meager social media following that had the potential to taint the jury. Theoretically, the gag order by law, when they are imposed, are supposed to be designed to protect the defendant's right to a free trial. In this case, I see something far more sinister. Although the judge has not ruled on this, I expect her to grant the government's motion. What say you?
I agree with you. This D.C. Obama Judge Tanya Chutkan. She was appointed to the federal bench. So was her husband. She was an Obama donor, and she has been the harshest sentencer of the January 6th defendants, harsher than I think every other federal judge. At the same time, she makes excuses for the much more dangerous, much more deadly BLM and Antifa rioters. She was very soft on criminals until there were Trump supporters who were trespassing at the Capitol and taking selfies on the Senate floor. And then all of a sudden, this Obama judge, Tanya Chutkan, became very tough on crime. Remember, President Obama stacked the D.C. district courts and the D.C. Court of Appeals with hardcore leftists, Marxists. This Tanya Chutkan, her grandfather and her uncle were Marxist revolutionaries from Jamaica, right? And the apple doesn't fall very far from the tree. And that's been proven over and over and over again with her left-wing rulings, where she is particularly harsh. Like you said, what happened to you was so un-American, and it set such a dangerous precedent in our legal system. It is the defendant, not the government, that has the Sixth Amendment right to a fair, public, and speedy trial. The government does not have a right to a fair trial. The government does not have a right to a public trial. The government does not have the right to a speedy trial. The criminal defendant does. It is American citizens, particularly criminal defendants who need it the most, who are allowed to speak out against their government under the First Amendment. Criminal defendants are allowed to criticize the judge. They're allowed to criticize the prosecutor. They're allowed to criticize the process. The only time that criminal defendants cross the line is if they are criminally obstructing justice by intimidating witnesses, which is a very high bar. And you monitor that through the criminal justice system, through criminal prosecution, not an unconstitutional and un-American gag on a criminal defendant as they're going through the criminal process. This is what you would do in North Korea, Zimbabwe, and other third world Marxist hellholes like New York City, like DC, and like Atlanta now.
So let's go back to the question now of the 14th Amendment, because I see exactly what you're talking about. First of all, I think it is important to note that at least so far, the charges brought against President Trump in DC do not include seditious conspiracy, do not include insurrection against the United States, which would, if he were convicted, would eliminate his ability to seek a federal office. I have seen a brilliant argument by the criminal defense lawyer David Schoen as to why the 14th Amendment, Article 3, does not apply in this sense, that the qualifications to be president of the United States are laid out elsewhere in the U.S. Constitution. But just because, let's say, the Secretary of State in Colorado, who's a leftist Democrat, just because it is their opinion that Donald Trump participated in an insurrection, he should be barred from the ballot. Wouldn't it, or shouldn't it, take some conviction in some court to make that assertion?
Absolutely. And David Schoen is talking about the legal argument made by Stanford law professor Michael McConnell, who is a former judge, former appellate judge, federal appellate judge on the 10th Circuit Court of Appeals that is based out of Denver, Colorado. When I clerked for then Judge Gorsuch on the 10th Circuit, Judge McConnell was on the 10th Circuit out of Utah. It's a Denver-based court. Judge McConnell is no fan of President Trump by any means. He's conservative, he's libertarian, but he's not a Trump fan, and he's made that very clear. But Judge McConnell, Professor McConnell now has made it very clear that what the Democrats are pursuing is very dangerous. This is the most anti-democratic thing you can do in a country like this, where you have these partisan election officials, whether it's the Colorado Secretary of State or the New Hampshire Secretary of State or some other partisan official who thinks that they can just take a presidential candidate off the ballot. Here's what happened with the 14th Amendment. We fought this Civil War, the Union won, and they passed the 13th, 14th, and 15th Amendments to outlaw slavery, guarantee due process and equal protection of the law for the freed black slaves, and to give voting rights to the freed black male slaves. That was expanded to women later with the 19th Amendment, but that's what the 13th, 14th, and 15th Amendments did at the time. And as part of this, there was a concern after the Civil War that these Confederate sympathizers, even Confederate soldiers, were winning office into the U.S. House of Representatives and other offices, and they were undermining the Reconstruction and the post-war effort. They were undermining the Union after the Civil War. So they passed Section 3 of the 14th Amendment that disqualified people who engaged in insurrection or rebellion during the Civil War. They were disqualified from holding office. But how the 14th Amendment works is there is Section 5. So that's Section 3, the disqualification clause. There's Section 5 that gives Congress the power to pass legislation to give effect to the 14th Amendment, including Section 3's disqualification clause. And that was in 1869, I believe, that they passed the 14th Amendment. In 1870s, when they passed a federal criminal statute pursuant to Section 3's disqualification clause that deals with insurrection and that deals with rebellion and insurrection. That was updated to its current version in 1948, and it includes a disqualification clause. So if you want to disqualify President Trump for running for office under the 14th Amendment, a federal prosecutor has to bring federal charges under the specific federal statute for rebellion and insurrection. You have to present evidence. You have to convince a jury unanimously beyond a reasonable doubt that he's guilty. A judge has to enter a conviction, and an appellate court has to uphold that conviction as a matter of law. Until that happens, you cannot disqualify anyone under the 14th Amendment. And if anyone tries to do this, it seems to me that a Republican prosecutor should use Fani Willis and Jack Smith's bogus January 6th theory. Maybe a Republican prosecutor can bring racketeering charges against these people who are pushing this bogus disqualification theory.
Yeah, I'm actually surprised that no one has suggested a civil RICO case against Special Counsel Jack Smith, who's very clearly coordinating his efforts with the district attorney in Fulton County, with the district attorney in Manhattan. Again, I'm not a lawyer. I understand it wouldn't take precedence over a criminal case, but I do think it might be an opportunity to showcase the abuses that are going on. Let me turn, if we may, to the so-called documents case in Florida. I see a huge amount of debate in the public about whether the documents that were retained by Donald Trump were classified or not classified, which I think, based on my reading of it, is kind of beyond the point. The president, President Trump, takes the position that under the 1977 Presidential Records Act, he has the full authority to do whatever he wants with his records, regardless of the classification of those records. That seems to me to be consistent with a decision by Judge Amy Berman Jackson, ironically the judge in my case, which upheld President Bill Clinton's authority to keep his presidential documents, which he in fact left some of them in the sock drawer in his home. So is President Trump correct? Is all of this much ado about nothing, or do they not seek to convict the president over his handling of documents, but instead charge him with some process crime, in this case the crime of obstruction, I guess?
Yeah, so I've been talking about this. It was a lonely fight for 13 months, Roger, but I'm glad that Republican members of Congress are finally finding the backbone to fight back after we've changed the poll numbers on this, where 60% of Americans see this Jack Smith prosecution for after the Mar-a-Lago raid as a political hit. So again, it's amazing that Republicans have found their backbone, and it seems like the DC swamp is the only place on the planet where the reptiles lack backbones. And so I'm glad that they're finding theirs. But yes, under the Presidential Records Act, Trump was absolutely within his rights to have his presidential records. Presidential records are any document created or received by the president or his White House staff. And under the Presidential Records Act, so if a document is created by the CIA or the FBI and sent to the president to advise him, those are presidential records. And under the Presidential Records Act, he's allowed to access his presidential records anytime he wants. So the argument is under the Clinton software case, President Clinton had 8 years of highly classified audio recordings of his presidency, 79 tapes stuffed into his software. And these were discussions he had with foreign leaders, discussions he had with his top national security officials. And Tom Fitton at Judicial Watch sued and said, he can't just take these government records. These are presidential records. They belong to the government. He can't just have these. And as you said, this Obama judge said under the Presidential Records Act, the fact that President Clinton took these records when he left office and didn't turn them over to the archives, to the librarians and the bureaucrats at the National Archives, deems these records personal under the Presidential Records Act. And so he gets to decide. The president makes the sole determination whether these are personal records that belong to him or they are presidential records that get sent to the bureaucrats and other librarians. They're government records, but he can access them anytime he wants. And so they categorize them and send it to the former president to put in his library. Regardless, under the Presidential Records Act, the president has the statutory right to access his presidential records any time he wants. And so if he has the right to have these records, how is it espionage for him to have these records? How is it espionage for him to not turn over these records? How is it obstruction of justice to not turn over records that he's allowed to have under the Presidential Records Act? There is an OLC binding legal opinion on Jack Smith and the Justice Department from 2019 that it is nearly impossible to obstruct investigations into non-crimes. If it is not a crime for the president to have his personal records or presidential records under the Presidential Records Act, how is it obstruction of justice of President Trump's being a jerk and telling the librarians to pound sand they can't have his records?
I have spoken very widely about the attempted crucifixion of former New York City Mayor Rudy Giuliani. All Rudy Giuliani seems to me to have done is to zealously represent the point of view and the legal interests of his client, former President Donald Trump. In both the DC case and in the Fulton County case, it seems to me that you have an underlying premise that Donald Trump knew in his heart and in his mind that he had in fact lost the election and then corruptly conspired with others to hold on to power. In other words, as I understand it, mens rea, his state of mind. The problem with that, of course, is that it doesn't matter who told Donald Trump that he had lost. Based on the anomalies and irregularities in that election, $300,000 ballots popping up in the middle of the night in Michigan while Republican observers were barred to watch their counting, just for example. I don't know how they prove Donald Trump's state of mind in order to meet the threshold for their basic charges. How is this possible?
Well, even if everything that Jack Smith and Fani Willis allege, even if everything they allege is true, there is not a crime. They're not alleging a crime. It is not a crime to object to presidential elections. It is allowed by the Electoral Count Act of 1887. If it were a crime to object to a presidential election, Democrats would be in prison for objecting to Republican wins in 1968, 2000, 2004, and 2016. It is not a crime to twist arms politically. If it were a crime, that's protected by the First Amendment. It's not a crime to be a jerk. If it were a crime to be a jerk, every politician in America, except for Chuck Grassley, my former boss, who's actually a nice guy, but just about every other politician in America would be in prison for being a jerk. This is election interference. This is lawfare. Unless there is evidence that Rudy Giuliani had the real electors tied up in his trunk and sent in fake electors with fake IDs, there's no crime here. This is absurd what they're doing here. They're trying to criminalize the political process. They're trying to criminalize political disagreement. They are criminalizing protected speech and protected conduct under federal statute, the Electoral Count Act of 1887, and the First Amendment.
As you know, former White House Chief of Staff Mark Meadows, a man I do not know, a man I've never communicated with. I did meet him once many years ago in a green room at Fox when he was a congressman. So contrary to sworn testimony before the January 6th committee, I had no communications with him on January 5th or 6th or any other date through any medium whatsoever. Cassidy Hutchison. So, but he has moved to remove the charges against him in Fulton County to federal court. It is my understanding that while he has some argument, President Trump has a much stronger argument in terms of removing the charges in Fulton County to federal court in his case, but so far he has not made such a motion. Your thoughts?
Well, I mean, so look, if you're bringing charges against a federal official for what they're doing in their official capacity, that should be removed to federal court. That there is a federal removal statute, and the whole purpose of that is you don't want local prosecutors and local judges hobbling the presidency and the executive branch with bogus indictments and bogus charges that go to state court. You bring them to federal court, where these judges are supposed to be more insulated from the political process. They're lifetime appointed. They're pay protected, and they're supposed to look out for the national interest instead of the local interest of the local prosecutor and the local court. Separate from the removal, President Trump and his lawyers need to move forward with a motion to dismiss both of these January 6th indictments, both by Jack Smith in D.C., a partisan hack Democrat operative who got unanimously reversed by the Supreme Court 8-0. It would have been 9-0, but Justice Scalia passed away before he could rule when Jack Smith brought bogus corruption charges to take out Virginia Governor Bob McDonnell, a likely presidential or vice presidential candidate in 2016. Jack Smith got unanimously reversed by the Supreme Court several years later, but the damage was already done to Bob McDonnell. They took him out. Jack Smith is running the same play here with President Trump, both in Mar-a-Lago and with January 6th. Jack Smith is a political scud missile Democrats send in to take out Republican presidential candidates or vice presidential candidates or inconvenient Democrats like John Edwards in North Carolina. But regardless, President Trump should move forward with these motions to dismiss in D.C. and down in Georgia under two different grounds. Number one, presidential immunity. To the extent that President Trump is acting as the president of the United States, what he did is in his official capacity, he is immune from prosecution under the theory of presidential immunity. It's a branch of sovereign immunity. And if you're the president of the United States is telling his vice president to do something, that's obviously within his presidential powers, because he couldn't do that as a private citizen. A private citizen couldn't order a vice president to do anything. A president could. Alternatively, if President Trump is acting within his personal capacity instead of his presidential capacity, what he did was protected by the First Amendment. Again, it is only a crime to object to presidential elections and to twist arms politically in third world Marxist hellholes like North Korea and Zimbabwe, and now New York, D.C., and Atlanta.
Unfortunately, it would be both naive and realistic to pretend that the courts at all levels are not affected by the national political atmosphere. A number of the court rulings, both federal rulings and Supreme Court rulings in the wake of Watergate against President Richard Nixon were constitutionally incorrect, or as lawyers would say, wrongly decided. But the atmosphere in the country was so virulently anti-Nixon that Nixon nor his point of view could ever get a fair hearing in the courts. And so many of those rulings set precedents for future abuses of presidential authority and indeed executive privilege. I'm a political animal. I'm not an attorney, but I recognize that Donald Trump is experiencing a political resurgence in this country that is unlike anything that I have seen in 45 plus years in American politics. I am a student of Donald Trump. I have watched Trump's poll numbers since we began taking them in 1988, just to gauge what public attitudes were towards him. I have seen a dramatic shift in those numbers in recent weeks that are unlike anything I've ever seen in as a veteran of 13 national Republican presidential campaigns. I know, Mike, I look much younger than I am. But it is really, it's quite extraordinary that the entire campaign of lawfare against him is backfiring so spectacularly. I can't tell you that I know how this ends. James Michael Curley actually was elected mayor of Boston while sitting in a prison cell. It is conceivable that if Donald Trump is convicted of some crime that does not include insurrection and therefore is eligible to be on the ballot, and assuming that he defeats these various state-based efforts to prevent him from being on the ballot without valid basis, just because it is the opinion of some Secretary of State or some other election official that he participated in an insurrection, but there's no underlying judicial decision that says that. It is not inconceivable to me, and he seems to be ready for this, just reading his public comments, he could actually get elected president while unfairly and unjustly incarcerated. Is that possible?
Sure. I mean, the qualifications to be president are outlined in the Constitution, and there's no disqualification for any crime other than for impeachment and removal. So if he were impeached and removed, you can disqualify, or the disqualification clause for insurrection or rebellion. And they're not charging him with insurrection or rebellion after the January 6th Kangaroo Commission spending tens of millions of dollars, and the Biden Justice Department spending tens of millions of dollars, and the media spending many, many months looking for insurrection or rebellion evidence against him. How many insurrectionists get to the floor of a nation's capital and walk through velvet ropes and take selfies and follow police direction and don't burn down the place? January 6th was a lawful protest permitted by the National Park Service that got out of control. Some would say provoked, but it got out of control. It turned into a riot. It was not an insurrection. I mean, it's just silly to say it was an insurrection. If it were an insurrection, why hasn't Trump been charged with insurrection or inciting insurrection or rebellion? He said to go peacefully. They had a permit from the National Park Service. So separate from that, think about what they're doing to Donald Trump. The American people see right through this. And, it's after 1,000 media hits, over 1,000 media hits that I've done over the last 13 months, I hope that Article 3 Project has played a small part in changing public opinion on this stuff, because 13 months ago, everyone thought that Trump was toast after the Mar-a-Lago raid. And I'll tell you what we've been saying all along is this is lawfare. This is election interference. How are they going after President Trump for records he's allowed to have under the Presidential Records Act, while Garland secretly colluded with Biden for 2 months to cover up 5 stashes of stolen classified records that Biden had as vice president and even a senator, moved several times unguarded for years, likely accessible by their Chinese agent and almost certainly used by Hunter to secure foreign bribes and other corruption for the Biden family. And they're going to go after Trump for records that President Trump had in the congressionally funded and heavily secured with Secret Service protection 24/7 office of the former president, with federally funded staff, with security clearances, Secret Service protection. This is obscene what they're doing to President Trump, and the American people are starting to wake up and see that this is obvious election interference. This is obvious lawfare. It's kind of like what the Democrats did during the Kavanaugh proceedings that I helped run on the Senate Judiciary Committee as then Chairman Chuck Grassley's chief counsel for nominations. The Democrats couldn't just stick to Christine Blasey Ford, who was lying through her teeth, but she was the most credible of all the dingbat bimbos they rolled out during the Kavanaugh confirmation. Instead, they brought in 5 other allegations against Kavanaugh, including Michael Avenatti and Julie Swetnick, and it turned into a clown car. And every subsequent allegation against Kavanaugh made Christine Blasey Ford's allegations look cheaper and cheaper and cheaper and less credible and less credible and less credible. And in 2018, when Democrats won the House of Representatives, and it should have been a good year for Republicans, they lost 4 Senate Democrat incumbents. The same thing's happening with Trump. They can't just stick to the Mar-a-Lago raid. They brought 3 other indictments for nonsense, and it's backfiring.
Let me shift gears here just a little bit, if I may, because I'm curious about this. You are obviously familiar with the final report of Special Counsel John Durham. John Durham essentially asserts, quite forcefully in his long-awaited report, that there was no probable cause, in other words, no actual evidence of Russian collusion with the Trump campaign to justify the appointment of Robert Mueller as special counsel, to justify the FISA warrants that were not only issued, but repeatedly renewed, even though the government officials involved were fully aware that there was no legal rationale for their issuance. And among those who I think come across very badly in the report, including President Barack Obama, Vice President Joe Biden, Attorney General Loretta Lynch, FBI Director James Comey, our CIA Director John Brennan, and former NSA Director General James Clapper. Quite obviously, Mr. Durham took his sweet time in order to ensure that although the revelations that were a bombshell to some, not to us, but to many, that nobody would really be prosecuted, that the statute of limitations would have run out. So Hillary Clinton, John Podesta, Jake Sullivan, all of whom were in on this illegal hoax, the greatest single dirty trick in American political history, essentially the use illegitimately and illegally of the full authority of the U.S. government for strictly political reasons to weaponize an effort to remove a duly elected president, that nobody would be prosecuted. Now comes news that the Department of Homeland Security Secretary Mayorkas has named former CIA Director James Brennan and former NSA Director John Brennan, pardon me, and James Clapper to an intelligence advisory board at DHS. What is undisclosed is whether this means they are back on the federal payroll. What we also don't know is if that means they get their security clearances back, although I'm not even certain that even though President Trump ordered their security clearances canceled, that they were actually ever canceled by the bureaucracy during the Trump years. What do you make of this? To me, it just appears to be a thumb in Donald Trump's eye. It essentially says, we can break the law at will, and we will pay no price for it whatsoever. How do you see it?
Well, they're gearing up for their next election interference. They've done this for several election cycles. Now, remember, President Obama is a radical. He's a leftist. He's a Marxist. He's not an old school liberal Democrat who just disagreed with conservatives. He is a leftist, and he was very effective at stacking our federal law enforcement, including FBI and our intel community, including the CIA and these DHS program agencies. Obama was very effective at putting these operatives in these key career positions, and they stayed there during the Trump administration. They're still there. And remember what they did to President Trump before 2016. Hillary Clinton had her illegal home server that evidenced the Clinton Foundation's illegal pay-for-play, foreign bribery, and corruption schemes. And this illegal home server was almost certainly hacked, probably by the Russians, probably by the Chinese. And so the Clinton campaign knew that this could come out before the 2016 election. And so they wanted to get out in front of that. And how did they get out in front of that? They tried to make it look like that President or then candidate Donald Trump was colluding with the Russians, this dirty trick. And so if this came out, they can say, no, this is all BS. This is just Trump playing dirty tricks with the Russians. This is Russian collusion. And you say, how can you say that? That sounds like a conspiracy theory. The Democrats ran the exact same play in 2020. You had Biden, you had Hunter Biden and the Joe Biden and James Biden and every other sleazeball Biden taking tens of millions of dollars from China, from Russia, Ukraine, every other scumbag armpit of the earth, and Hunter Biden's laptop gets discovered, right? And so it's getting ready to come out that this laptop is going to go public with all this Biden foreign corruption, foreign bribery and corruption. What did the FBI, what did the CIA do? They had these 51 former intel goons put out this letter that had all the hallmarks of a Russian disinformation campaign. So if this laptop came out, they can say, no, this was another dirty trick by the Russians, and then they can go to big tech and big media and say, don't report this. And so the New York Post, America's oldest newspaper, when they broke this story, was censored. And not only were they censored where this story was not reported anywhere, they had big tech censor this so it wouldn't be the link could not be shared on social media. And they even had it where Amazon made it where the link could not even be posted on the internet. They're doing the same thing. They're going to do the same thing in 2024 with President Trump. They're already weaponizing our law enforcement and our intel agencies again to go after President Trump on this Mar-a-Lago raid because President Trump had his declassified Crossfire hurricane records. He declassified them via presidential memo the day before he left office, and he took his personal copy of these presidential records. That's why we had the Mar-a-Lago raid, is because these Crossfire hurricane records are so damning. They blow the lid on Clinton and Obama and Biden and Clapper and the rest of these goons on the Russian collusion hoax. They've done it for 3 election cycles. So when you say they're getting their security clearances to put the thumb in the eye, that's part of it. I actually think that they're getting their security clearances to make them operative again.
Excellent observation. One of the most disappointing things in Mr. Durham's report is that while he debunked the totally fake Steele dossier, which was paid for initially by Hillary Clinton, and had false allegations of sexual misconduct in Russia by President Donald Trump when he was visiting there, owning a beauty pageant, they never really addressed the falsity of the CrowdStrike's report, which falsely claims that the Democratic National Committee was the target of an online hack. We now know definitively that the FBI in my trial admitted in pretrial motions that they never examined the servers of the DNC. They admitted that they relied entirely on the representations of a company called CrowdStrike. And then the head of CrowdStrike, a man named Sean Henry, who just happened to be a former deputy of Robert Mueller's at the FBI, testified under oath before the House Intelligence Committee, although it was classified for a long time, that his report included no proof whatsoever that the DNC had been the target of an online hack. So the whole false narrative, which I imagine at this point half the people in the country probably still believe, that the Russians hacked the DNC and somehow gave that information to WikiLeaks, is provably false. When my attorneys, my defense attorneys, wanted to use expert evidence, forensic evidence and expert testimony by former counterintelligence figure Bill Binney, as well as James, I think it is, McGovern, the judge, of course, would not allow that. I'm afraid President Trump is going to find that his defenses in the days ahead are going to be similarly limited. Mr. Durham chose not to address this question at all, which means that later this evening, when I go out to dinner with my family, there's a 50-50 chance that some libtard is going to assault me as a quote-unquote Russian traitor. These liberals have no tolerance. They also are uninformed about the facts. This has been great. I want to thank our guest, Mike Davis. Mike, give us a quick rundown, if you will, on the Article 3 project, because what you're doing is so very important.
I really appreciate that, Roger. I started the Article 3 project after I left the Senate Judiciary Committee because I saw how evil Democrats and the left were during the Kavanaugh confirmations, and I saw there was a void on the right. The Republicans, conservatives are too weak and naive to understand what's going on in this fight. And so that's why I started the Article 3 project. We defend these constitutionalist judges. They have lifetime tenure. They have pay protection. They're not supposed to care about the politics, but they're still human. So we defend these constitutionalist judges when they keep the government in check. We've defended President Trump for the last 13 months. Like I said, over 1,000 media hits, constant opinion pieces, constant social media engagement to defend President Trump. We have changed the public opinion on these Democrat indictments, this Democrat lawfare and election interference, where 60% of Americans see Jack Smith's Mar-a-Lago case, which is supposed to be the strongest one, as political. And we're going to fight to confirm constitutionalist judges going forward. We're going to have a key role when President Trump is back in office to help him pick his Supreme Court justices and his lower court judges, to make sure we pick constitutionalist judges with a backbone who understand their critical role is to protect everyday Americans from government tyranny and government breakdown.
All right. Thank you yet again. Mike Davis has a very lively feed on X, formerly known as Twitter. Let me pull that up if I may, or Mike, you can say it out loud. Go ahead.
Yeah, our website's article3project.org, article number 3project.org. You can donate there. We're on Getter, Twitter, Truth, at Article 3 Project, at article number 3 Project. My personal, when I'm not kicked off, is MRD DMIA, Michael R. Davis, Des Moines, Iowa. MRD DMIA. I know I sound like I'm from Brooklyn, but I'm from Iowa.
Okay. Mike Davis, not only a great patriot, but formerly worked for one of the greatest senators in American political history, a true American patriot, someone it's been my privilege to know since 1978, Senator Chuck Grassley of Iowa. They literally don't make them like that anymore. He is a standout in the current U.S. Senate. Even at his age, he's sharp as a tack and probably the number one protector of justice and freedom in this country. I salute you for your service to him, and I salute Senator Grassley for his great service to this country. Mike Davis, thank you so much for joining us in the Stone Zone.